Hello, my name is Tanya Hyrigs, and I'm a member of Group 5. To incorporate the political science discipline, we wanted to provide insight from a political science professor here at Morningside. Our initial plan was to meet in person with Dr. Privett, but he was unable to meet. We decided to conduct this interview via email. We emailed him with 4 questions in which he provided his insight. Here's how it went. The first question we asked was, what are some of the ways that a common law marriage differs from a formal marriage? He answered, formal marriages require a marriage license and a marriage certificate. Usually, couples will engage in some kind of formal ceremony, oftentimes religiously affiliated, to officially get married. Due to the legal nature of a marriage, every state has its own requirements for dissolution of a marriage divorce. Some states require all finances and assets to be divided equally between the two parties in the case of divorce. Politically, all U.S. states must accept and recognize marriages from all other U.S. states. This is due to the full faith and credit clause in the U.S. Constitution that states that each state must respect and give full legal effect to the public acts, records, and judicial proceedings of every other state in the United States. Interracial marriages, Loving versus Virginia, 1967, and gay marriage, Obergefell and Hodges, 2015, have been upheld by the Supreme Court to protect minority groups' rights to an abortion due to the full faith and credit clause of the Constitution. Common law marriage, on the other hand, does not have a formal procedure or license. However, the couple must intend to be married and present themselves as such, whether that be calling each other their spouse or partner, sharing finances, etc. The burden of proof falls on the surviving member of the couple in a court of law if one of the spouses passes away or terminates the relationship. In fact, many states do not even recognize common law marriage. The second question we asked was, why would a couple choose to cohabitate rather than get married? From a political, legal standpoint, are there any benefits to cohabitation? He answered, there are certainly upsides to marriage over cohabitation. Most notably, you receive additional tax breaks if you are married because you can jointly file your taxes. If a couple chooses to cohabitate, they might do so due to the legal flexibility. If there are fears that one partner will not stay committed, it is much simpler and cheaper to avoid formally marrying. There are financial reasons as well as not to get married, especially in the era of crushing student loan debts. Some people opt to not marry because they do not want to saddle their spouse with their financial problems. In addition, some government benefits may lapse if you get married. In particular, some disability programs require people to make below a certain income, and marriage complicates this. More personally, some people are ideologically opposed to marriage because they do not agree with engaging in the state function of marriage. The third question we asked was, how do different states or countries approach recognizing common law marriages? He answered, I cannot speak to how other countries recognize common law marriages. Through a quick Google search, though, it looks like Canada, Australia, and much of Europe legally recognize cohabitation as a civil partnership and or union, but they may vary in conferring full marital rights. My knowledge is fairly limited in the variance between the states as well. It looks like only Colorado, Iowa, Texas, Kansas, and Washington, D.C. recognize common law marriage, but I am unfamiliar with the details there. The fourth question we asked was, how have laws about cohabitation changed over time in the United States? Are there any key cases or changes in these laws? He answered, early laws in the United States outlawed cohabitation as lewd and lascivious behavior, but that has changed over time. Many states have since decriminalized cohabitation. The Supreme Court upheld unmarried couples' rights at various points in time by upholding their right to contraception, Einstead versus Byard, 1972, and right to engage in private consensual behavior, sodomy, Lawrence versus Texas, 2003. That concluded our interview with Dr. Privett. Thank you for listening.